Good evening, friends. Today I going to discuss the issue whether the property of a person who has conducted a bona fide transaction with someone who is found to be engaged in a money laundering, whether the property of such a person who innocently deals with a money launderer, whether his property can be attached within the purview of the Prevention of Money Laundering Act. We know that the Prevention of Money Laundering Act is a very stringent law. It is a sui generis legislation wherein there is dual objective of the law. One is to prosecute the offender who is involved in the process of money laundering. That means somebody who has committed the offense, not only the scheduled offense. Scheduled offense means those offenses which are there in the schedule to the Prevention of Money Laundering Act. So if anybody has committed any offense and also in the process and earned some money, then that is called the proceeds of crime. For example, suppose somebody commits a dacoity. So the act of dacoity is an offense under the purview of the Indian Penal Code. But somebody who earns the money out of that dacoity is a proceeds of crime. So within the purview of the Prevention of Money Laundering Act, under Section 4, the act of dacoity will be prosecuted under Section 4 of the PMLA Act, which will be tried by the special court under the purview of the PMLA Act, in addition to the trial within the purview of the CRPC before the appropriate criminal court. But at the same time, there is an attachment of the proceeds of crime. Now, anybody who does the act of money laundering, he interacts with the society. Suppose somebody who has conducted the dacoity, he buys a property, he buys a new house, or suppose he buys some other goods or services. He takes a flat on rent. Or he conducts any business transaction with the society at large. He may also, transact in his personal capacity. That is why suppose he gives the money to his near and dear one. He lets out the money to people associated with him. So the issue is whether the people who are doing dealings or business with a criminal who is involved in the money laundering activity, whether the property of such a person can be attached. For example, somebody who sold the property out of the proceeds of the dacoity, or somebody who lets out the property and rent and earns the rental income, or someone else who is gifted some money out of the such a proceeds of crime, whether such a person, whether that property, whether the earnings of such a person can be attached also. Now, in this regard, I think it will be important to have a look at the history of the legislation of the definition of money laundering. Money Laundering Act, before it was came into being, there was a standing committee on finance of 98 and 99. The law came into force from 2002. So there was a standing committee on finance 98-99, which proposed the definition of money laundering. And it proposed that whosoever acquires, owns, possesses, or transfers any proceeds of crime or enters into any transaction which is related to the proceeds of crime, either directly or indirectly, or conceals or aids in the concealment of the proceeds of crime, commits the offense of money laundering. So this was the initial definition where the word knowing was not there in the law. So while this definition was being discussed, the committee felt that this provision is very harsh, as it can lead to a situation where anybody who deals with any person who has committed any offense of money laundering can unwittingly and unknowingly be brought within the ambit of the act. In order to obviate such a situation, the committee recommended the words knowingly be inserted in the definition of the money laundering. So the law or the definition of the money laundering as it stands today, it says that whosoever directly or indirectly attempts to injure or knowingly assist or knowingly is a party. So first of all, somebody who directly or indirectly attempts to indulge in the process. So if somebody is directly indulging, obviously he is in the know of the things of what he has done or what he is attempting to do. But if somebody assists or is a party or involved in any process or activity connected with the proceeds of crime, for example, its concealment, possession, acquisition, or use, then such a person must be knowingly involved in such a process. So this word knowingly is very, very important. And in somebody who gets involved or deals with the money launderer, unknowingly cannot be prosecuted within the purview of the money laundering law, nor his property can be attached. Now here there is one judgment of the Honorable Supreme Court where no ratio as such has been laid down. But the judgment in the case of Directorate of Enforcement, whether Pardhanava Kishore, reported in 2022 SCC Online, SC 1490, it was held that whoever knowingly assists or knowingly is a party or is actually involved in any process. So on the word knowingly, a special emphasis has been added by the Honorable Supreme Court in the judgment in paragraph 15. But so while no ratio has been laid down by the Honorable Supreme Court, but by laying emphasis on the word knowingly, obviously the Honorable Supreme Court has tried to emphasize that the word knowingly is very important in the process of the definition of money laundering. Now, Honorable Karnataka High Court, in the case of Razorpay Software Private Limited versus Union of India, it was held by the Honorable High Court that somebody who is a payment gateway and had no knowledge that the funds transferred to the merchant ID of the accused were derived from criminal activity related to scheduled offense, nor they knowingly assisted the accused in concealing or transferring illicit proceeds, can be said to be part of the offense under Section 3 of the PMLA Act. Now, here, I think one observation of the Supreme Court in the case of a celebrated judgment in the history of the money laundering law is Vijay Madan Lal Chaudhary. Anybody who is dealing or practicing in the Prevention of Money Laundering Act must be aware of this judgment. And this judgment says that to be a proceeds of crime, property must be derived or obtained directly or indirectly as a result of the criminal activity. It is observed by the Supreme Court that there may be a vehicle used in the commission of scheduled offense, which may be attached in the concerned crime, but still it may not be proceeds of crime within the meaning of PMLA Act. So, for example, suppose a vehicle is used by hiring in conducting a dacoity. Now, that vehicle, while this vehicle may be seized by the police to unearth the evidence with respect to commission of that particular criminal activity, but that if the person who has given that vehicle on hire to the dacoits, it still may not be a proceeds of crime, as it has that vehicle has been not been purchased out of the proceeds of crime. At best, if the higher charges has been earned and if the person is aware of the activity, then that higher charges for letting out that vehicle may be attached. Here, before I conclude, I would like to point out one judgment in the context of criminal law, wherein one terrorist was being tried and he had taken a property on rent from someone, and there used to be telephonic call between the landlord and this terrorist. So Delhi High Court in this particular case, which is State versus Muhammad Arif, reported in 2007, SEC Online Delhi 1259, held that if merely on the basis of someone letting out his premises to someone who turns out to be a terrorist is considered sufficient to infer the knowledge on part of the landlord about his tenant being a terrorist, then the investigating agency in the presence should have prosecuted the owner of all the properties where the terrorist resided from time to time. So it is very essential that one must have the knowledge and the awareness. And for the purpose of the knowledge also, it cannot be said that one must have the knowledge. One can only exercise the reasonable skill, care, or caution to know the activity of the person he is dealing with. But it cannot be that one can act as an investigator and it can be said that why you did not do enough investigation to know that you are dealing with a criminal. It may not be possible to act as an investigator while doing an arm's length transaction under the bona fide belief that you are dealing with someone who is compliant with the law. So with this, friends, I conclude my today's session. Thank you very much.